Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein. I'm the Andrew and Ask Andrew, and I'm the managing partner of the Greater Toronto family law firm, Feldstein Family Law Group. I practice exclusively in family law, as well as my 10 associates who also practice exclusively in family law. Today, our special guest is Aiken Robertson, criminal and DUI being driving under the influence lawyer Justin Marchand. And we'll be discussing the overlapping issues of criminal law and family law. Please feel free to ask questions in the comments section. So let's begin. Welcome to the show, Justin.
Hello.
Hello, welcome to the show.
Thank you. It's nice to be here.
Okay, can you tell us a little bit about yourself and how you came to be a criminal lawyer and a DUI lawyer?
Well, very quickly, I completed an undergraduate degree from Dal, decided I didn't know what I was going to do with my life, ended up falling backwards sort of into law school, and then I fell backwards into criminal law from there because of articling. The particular field that I worked in when articling was essentially DUI law for the most part, which is mostly charter litigation. I can get into that a little bit. But then once I became licensed, I was picked up by Aiken Robertson, and I've been practicing predominantly DUI law since, although I do various other work, anything from frauds to assaultive behavior to, you name it, except for, murder, manslaughter, that kind of thing.
Okay. And from reading your website, I can see you have considerable knowledge about assault charges as well. Do you find that this type of criminal charge goes hand in hand with family law?
So I personally don't handle the family law side of things. However, in the context of ongoing family law litigation, often enough there will be an allegation of assaultive behavior, and as a result, the individual who's being accused will have a whole bunch of burdens and onuses put on them, which effectively prejudice them during the family law litigation, as far as I understand.
Okay, now, do you have many clients call you before the police contact them and ask for an interview, or before they meet with the police, or do they call you usually after the fact?
Generally, it's an allegation by surprise. Right, so the person, well, it depends. So there's two kinds of situations. One where there is an allegation that arises out of some sort of event on the spot, and the person will tend not to have a lawyer. So basically what happens is when there's an allegation made, police investigate. If it arises fairly in close in time to the events that give rise to the allegation, the person tends to be at a disadvantage. They don't know what to do. They're arrested, within an hour and a half after some sort of verbal dispute, and the other side's alleging some sort of assaultive behavior, and then they're asked, well, do you have a lawyer of your own? And typically people don't have lawyers on retainer, and most people don't come into contact with criminal justice system. So inevitably the answer is no. And it's becoming very routine to funnel accused into speaking with duty counsel. So they'll say something to the effect of, they should be saying, well, we can provide you with materials, for example, phone books, that kind of thing. In some cases, access the internet. But instead of that, they're moving over to duty counsel. The duty counsel lawyer will give them sort of perfunctory advice, and then they'll be calling my office a few days afterwards, a week after, that kind of thing. On the other side of things, sometimes the person has some advanced knowledge. Often enough in these sort of domestic disputes, there's some bribery, there's some sort of thing going on in the background where the complainant will have made threats that they will allege things, and then sure enough, those things are alleged. In that case, I will often enough be contacted before an arrest happens.
Now, I can tell you in my experience as a family law lawyer, we usually tell people don't move out of the house until you have an agreement.
Mm-hmm.
And I always counter that to my client by saying, do you have a concern that your spouse may call the police and allege that you've assaulted them or uttered a threat or something along those lines? And if that's the case, I tell them, well, you may want to have a discussion with a criminal lawyer, because the last thing you want to be facing is that you're out of the house as a result of being arrested on criminal charges and having a term of a recognizance. Now you have two lawyers that you're paying for and an extra battle. So I try to get the input of criminal lawyers at that stage for the clients to help understand whether they should stay or shouldn't stay, because to me, the criminal law aspect trumps the family law aspect.
So the issue is our system incentivizes a complainant in those situations, especially when there's a sensitive issue about joint custody over kids and staying in the same household. So a relationship will have broken down, and it's well known and well understood in the legal community, and perhaps not well understood enough in the general community, that it's a foregone conclusion in Ontario. If you are charged in a domestic, you are going to be put on recognizant terms that kick you out of your own home. They kick you out of your own home, and it doesn't provide for a process. The system, when they kick you out of your own home on a recognizance, they don't provide for a process for facilitating the rest of your life in relation to the home or the complainant or the kids that you share. So it really serves to disadvantage an accused, and that's part of maybe the litigation strategy some of the time on the other side.
Well, it may be the side of the party. I really hope that family law lawyers aren't counseling their clients to do that, because
I don't think that's happening necessarily, but it's not. Anybody who's involved in the system finds out very quickly that this happens. So, yeah.
And I know in my experience from seeing clients, it doesn't take a very significant allegation to warrant someone being removed. I always think back years ago, I had a client and he was having a discussion with his wife while he was making a sandwich. And he had a knife in his hand while he was making the sandwich, and he got angry with her and said something like, "Don't say that," and started waving his knife around. And the next thing he knew, his wife called the police and he was arrested because they said, uttering a threat with a deadly weapon or something along those lines. And he was out of the house.
Yep.
And he was quite dumbfounded by, I was making a sandwich. And that really taught me a good lesson for clients, because I say to them, if that's going to happen, you have to really avoid the conflict. I remember another client, he was in a separate bedroom in his house. The wife came and started yelling at him in his room. And he asked the wife, please move aside so I can leave the room. Wife said no. So he picked her up and moved her to the right. An hour later, he had a flashlight in his face and he was never back in the house again when the police arrested him. And when a lay person hears that, they have the reaction you just had, and you're familiar with it, which is, how does this make any sense? But someone realizes the tactical advantage that they have. And I even think of the scariest thing I once heard someone say to another professional. They meet with this professional every so often, and their comment was, I come home every night hoping that my spouse will hit me. And it was really shocking because they wanted them out.
And I've seen situations set up where there's where the person will intentionally put themselves in front of a door, for example. So it might be in an engineered situation that gives rise to the allegation.
And the real unfortunate part of this is domestic violence is a problem. And domestic violence is a serious problem that happens far too often in society. And we're talking about those small percentage of times where it doesn't happen and how quick the police are to arrest. But from a litigation standpoint, one of my pet peeves, and it may have a lot to do with your point, that duty counsel is usually the one that arranges the initial bail. But I always like it when I see the recognizance and it says that it's subject to any term contained in a family court order or agreement between, or written agreement between the parties. Because when that arrest happens, what people haven't thought about is the facilitation of the exchange of the children. Because the one who has got the other one arrested may have to do all the driving for the parenting time and not realize it. Because if someone is removed from the home and the only place they can get their surety to stay at may be at their mother's or their brother's or their father's, which could be a 30-minute drive. And they're going to say, but I can't go do pickup because I can't go to your house. And the person who's being kind enough to let me stay in their house is also saying they don't want to go do an hour drive every time there's pickup. So now all of a sudden, the person who is assaulted finds out that they need to do the drive to the McDonald's that's 2 minutes away from where their former spouse is staying. So people don't realize the ramifications that it's creating. And even for the person who is the victim of the domestic violence, it's advantageous to give the ability to a family court judge to make that order. And some people don't appreciate that a family court judge can't override what the criminal court judge is ordering. They're two distinct actions, so that the criminal court needs to allow for that. And I don't know if that's something you do in your practice.
Absolutely. It is so what you're referring to is negative externalities, things that are not directly contemplated by the criminal code provisions that impose these obligations and the recognizance and so on. And typically family court orders being introduced into some sort of order on an individual comes either during the litigation as part of a bail variation, because often enough it won't be part of a recognizance, unless the person's been show caused, which means that they've been held for bail, and that's often the case, especially if there's going to be a surety release. But often enough, they don't find their way into the initial Form 10 releases or the bail releases, and so it's either introduced as part of a bail variation down the road, and very often, in fact, where most comes up is probation or peace bond conditions. So somebody will go through the criminal justice system, be concluding their matter, and be placed on either a probationary term or perhaps a peace bond, which is part of a resolution. And in those terms that will last for up to 3 years on the probation side, or up to 12 months on the peace bond side, if it's statutory, there'll be terms that allow for the family court orders to facilitate access, notwithstanding the peace bond or the probation will prohibit contact or communication.
The last thing, and then we're going to take some questions that came in, but the last thing I'll say too is sometimes people also forget to put in that they should be able to attend a settlement meeting with the lawyers present. When you get into a criminal issue of the restraining order, we as family law lawyers are concerned that we can't get everybody together in a room. Now, it may be that the victim of violence doesn't want to be in the same room, but sometimes they may want to be. Or if we're going to a mediation with lawyers present, we may want them there. So allowing that to take place helps, and one could argue that it is a written agreement. If it allows for a written agreement, not just a court order, you can have a written agreement for the attendance to take place. Now, I did see that we had some good questions that came in on Facebook. The first one is from, I think, Yolande, says, the daughter is 12 and ready to turn 13. Does she have the right to decide who she wants to live with? She has severe anxiety. The answer to that is, at 12 turning 13, in my opinion, no, she does not have the ability to decide where she wants to live. And when you go to court, there's a principle under the Divorce Act called the maximum contact principle that suggests children should be able to have maximum contact with both parents. A child of that age may have a voice that will be included. That may be through the Office of the Children's Lawyer, maybe the Voice of the Child report, and that's given some weight. But it's not up to a child at 12, 13, 14, 15 to just simply make that decision. There's a certain age, depending on the maturity of the child, and their thoughts and their views and their preferences are relevant. And it's also important that their views and preferences are truly independent and isn't something that was coached by one of the parents so that they would express that viewpoint. I can tell you that those who have been on the receiving end of parental alienation will say it is one of the, if not the worst thing that they've ever experienced in their life. I see we have another question from Facebook Live, and that one is from Ivana. My spouse is using criminal charges to challenge my claim for custody. How can I refute the charges? Now, there's really two different questions with that. There's one is going to be, and I'm going to ask Justin to answer that one, which is from a criminal law perspective, how do you deal with it? And then I'm going to deal with it on the family law side. So Justin, why don't you take it away with that question?
So what I presume here is this is an allegation of assault in a domestic context, obviously, and the practical realities differ from the theoretical realities. The practical realities are fighting a charge to the very end is not necessarily the best route or advantageous. Aside from the fact that fighting the charges to the very end, so to speak, typically means a trial, and that trial can happen many, many moons into the future. Often enough, it's advantageous to resolve, and to resolve by way of, it gives you certainty, and so it's often by way of a non-criminal disposition, like a peace bond, which is it's in the criminal code statutorily. It's also available via common law, and it most often results in the charges being withdrawn as part of this sort of quid pro quo that our system has developed. There's basically an incentive to resolve on both sides, and so charges often don't proceed to trials. So it really is. So the concept of how can I fight my charges is not maybe the best way of thinking about it. It's more about thinking about what you want and what consequences will flow from what you want or what you should take. So, for example, if for example, leaving the house or being kicked out of the house as part of probation or something like that is fatal to your family law litigation, or you're trying to get your kids or something like that, then you might need to take it to trial ultimately. But then it also raises other issues of the fact that, practically speaking, you won't get a trial within 6 months or 8 months or 9 months of the charge. And then you've created a distance of time that might have implications with what you were mentioning about leaving the house and not leaving the house. So there's a lot of considerations to that. And my feeling is that it depends on the results you're aiming for and a thorough consideration of the consequences for the results.
Okay, one of the things we get into in family law is going to be the status quo. So when someone gets arrested and removed from the home, it's creating a new status quo. Now, the case law will say you don't look at the status quo, you look at what existed before the date of separation, but practically speaking, you're creating that. And from a family law perspective, what's really important is continuing the contact between parent and child. So typically, when one side makes the call, the children are going to stay in the home they're familiar with, because that parent now has the parenting time in that home. De facto, exactly. But the other parent now has to try and facilitate a schedule. They may want an equal time schedule, but then you have to deal with the practical realities. If someone is removed on criminal charges and their parent or their brother that they can stay with, who has room for them and room for their children and is willing to take all of them into the home, says, I'm prepared to support you in an equal time schedule, you might be able to get that by either A, demanding it from the other side who's going to say no, or B, running to court with an urgent motion if they're not giving you appropriate parenting time. But the problem is you have to have the good fortune that you can secure that accommodation to allow for equal time to work. Because if you have someone who lives in Thornhill and the parent lived in Forest Hill of Bathurst and Eglinton, even if they have the space, equal time just won't work if you think of the commute in the morning for the child to school. So there's practical considerations that are going to put you at a significant disadvantage simply because of geography that you may have absolutely no control over. So different people have good fortune to challenge it than other people do. And because the family court order is not going to provide for giving either side exclusive possession at that point, because it's going to rely on what the criminal order says, that person is in real jeopardy in their case. Now, there's another question here. I think it's from Ivana. My spouse and I have joint custody of our son. When I attend play or sporting events, my spouse often calls the police, charging that I make her feel unsafe. What can I do? This is one I've heard, and here's what I'll start answering it first as a family law lawyer, and then I'll offer it over to you, Justin. I'm always worried about the optics that take place when I take my clients to court, because when you go to court, anything can happen, and you want to demonstrate that your client seems to be very reasonable and level-headed. And that means that you want to give them advice on how to avoid conflict. That doesn't mean I tell the client not to show up at their son's hockey game or their daughter's hockey game or gymnastics, but it's how they show up and what they do. It has to be done in a way to completely and utterly avoid conflict. So if I'm going to a game and I'm worried of being accused of conflict, I'm going to probably want to bring somebody else with me. I'm probably going to want to go to that game with someone else, drive in with someone else, and leave with someone else. Because you might think, well, I'm in the stadium, everyone can see I'm not doing anything and minding my own business. But your good fortune will be that when you're leaving, you'll be accused of saying or doing something. So make sure you are never alone. And it can even be beneficial, leave before your spouse leaves. Arrive before your spouse arrives, if you know what their schedule is and you're able to make it work. Do everything you can to just avoid the conflict. What would you be advising? I think we're having a technical difficulty with Justin in terms of answering the question. I apologize to our viewers because we can't hear what Justin is saying right now, and it seems that his audio has gone out.
I'm back.
He's back. Wonderful. So now if you can answer that question.
So I would mirror exactly what you've said, and I would add, and I actually gave this advice today, this morning, that if you feel you're approaching a conflict situation, we all have these devices now. And I advised my client not to be overt about it, but to simply flip on the video recording option, because it's sometimes just the best way of safeguarding yourself against false allegations.
And this is where family law lawyers and criminal law lawyers will diverge, because from a family court perspective, the judges hate the optics of one parent having to record what's taking place between them and the other parent in the plain view of the child, because they're concerned about the message it's sending to the child, that mom and dad's relationship is so toxic that there needs to be a video of it. So I understand from a criminal perspective what you're saying, but from a family law perspective, we actually tell our clients not to do that. And that's why we prefer to have other witnesses there. So, taking it one step further, I think of a hockey game. If I was worried that my ex-wife was going to make allegations, I probably would go with one or two of the other parents to the game when it's not my parenting time, and make sure I leave with the other parents as well when it's not my parenting time. So I'd always be surrounded by people to make sure the allegation couldn't happen, and therefore there'd be no need of the video recording.
Yeah, so the same thing. So the video recording could be in place of somebody, and in this case, clearly, if somebody's in a family law situation, they would be taking your advice and having somebody in place of the camera, a witness.
Yeah. Now, we did have a question that came in before the show on Facebook, where it's about adding a party to a matter. And it says here, the ex has put his home, all bank accounts, and credit cards in his current wife's name to avoid full financial disclosure. Would the best course of action be bringing a motion adding his wife as a party? And the answer to that actually is quite simple. The family law rules provide you the ability that you don't need to add someone as a party to the action initially. You can actually bring a motion, and it's called a third-party motion, where you have to personally serve the third party. And if you personally serve them and you name them as part of that motion, they will be a party for that motion, and the court will have the ability to make orders for disclosure with respect to the third party. And in fact, there's a 6-part test, but the hardest part of that test is it would have to be unfair for you to proceed without that information. And from what you described, I'd be very confident that you would end up getting that information. I see we have another question came in on Facebook Live. This is from Glendon. He says he separated in February of 2017 in Manitoba. Both of us moved over the summer, me to Ontario and her to BC. You're both military. When can you apply for divorce? It's actually a great question. The Divorce Act is a law that applies across Canada. But in order for you to commence an application for divorce, you have to be a resident in the province that you're living in for 1 year. So you could commence in either province if one of you is living there for a year. So for example, if she's living in BC for a year, then you can commence in BC once she's living there for a year, or once you're in Ontario for a year, you can commence here in Ontario, or she could. I assume the interesting problem is if you're getting transferred a lot as part of the military, and whether or not you have that 1 year period of time. I would have to actually do research on case law to see if there's an exception for military duty, because that would somehow seem logical as an exception, but I don't know whether that's the case or not. I think it's pretty rare I get stumped on here, but that one may have a very fascinating legal issue that could warrant a change. Now, as I move on, I had some preset questions, and one of them is about abuse in relationships, including behavior ranging from threats to physical or sexual assault, which could be harmful financially, emotionally, and verbally. What type of lawyer do you recommend someone hire if they're getting abused and they want a divorce? That's for you, Justin.
Oh, so I would say that's two separate issues. The first is if you are being assaulted, then your obvious recourse is either to make a criminal complaint or launch a criminal action against another individual through it's called a pre-enquête hearing. They're relatively rare, and they're usually instances where the police, for whatever reason, aren't proceeding with the charge, and one goes after them. And there's also peace bonds. So peace bonds, you can petition somebody into a peace bond, and it's also like an action towards somebody that is privately initiated, and that's to create conditions on the other individual. I mentioned it before, where people voluntarily enter peace bonds, or they show no cause, as it said, show no cause to refute the peace bond, basically the petitioner. And so those are your options. It's either go to the police, or peace bond, or the pre-enquête. And then as far as a family law lawyer, certainly it doesn't hurt to have your criminal lawyer and your family law lawyer in touch with one another to ensure that there's a harmonious approach to litigation where an harmonious approach is necessary.
Well, do you ever have people who are victims of domestic violence contact you with questions about whether they should go to the police or not go to the police?
Generally speaking, people don't contact me for whether they should make a criminal complaint. They tend to contact me after they made a criminal complaint, and they want to be in part of that process often enough because they might have exaggerated or confabulated, and now they're wanting to be a part of the process to clarify the record, but they're concerned they're going to get charged with confabulating or lying, misleading police. And sometimes they even feel, and this is in some circumstances, by no means, these are all individual circumstances, this is experience here. They'll sometimes feel that the police are not listening to them beyond what was simply initially stated during the heat of the moment, and they'll seek access to the system through a criminal lawyer like myself.
Okay, well, I wanted to thank you for all the information you've provided, and thank you for coming out to the show today. I think you provided us with some fascinating information for the viewers. And lastly, if anyone's interested in following Justin on social media, you can follow him at his Twitter account, which is at R. Aitken Robertson, or on Facebook at facebook.com/wefightthecharges/ The next Ask Andrew show will be the last one for this calendar year, and it will be on December 14th, 2017 at 1 p.m. Our special guest is Todd Werbowski. I really hope I got the pronunciation proper. He's president of Canadian Divorce Financing, and we look forward to seeing you then. And thank you for watching today.
Thanks for having me.